Hi, good afternoon. For those of you joining us on Facebook Live, my name is Guillermo Hernandez. I'm an immigration attorney in San Antonio, Texas. I'm here with my colleague Roberto Campos, also an immigration attorney with our offices. We work for the law firm of Vidauri, Lyde, Rodriguez, and Hayes. We have offices here in San Antonio, and we have offices in the Valley, in Edinburgh. And we take immigration cases, pretty much of all kinds. We do a lot of family petitions, residency, naturalization, deportation defense, immigration court cases, asylum, investor and employment-based or business-based immigration cases as well. And so if you have a question, I invite you to do your question in the comments of the video. We'll be glad to answer any questions that come up. Our show or our live today will be in English. We'll be on for about 30 minutes, but if you do have a question in Spanish, we can also answer in Spanish as well. And we have our English show every other week during the lunch hour, and our Spanish show is on the other week, the alternative week, so it'll be next week at 6 p.m. And you can tune in for immigration updates, and we usually try to pick out a theme of what we're going to talk about. So today we're going to be talking about just some general immigration updates and also in more detail about applying for naturalization or citizenship in the United States. Last week on our Spanish show, we talked about the process of seeking a waiver for unlawful presence, more specifically in the family petition process and the consular process going abroad to secure your visa. So I think next week, Roberto, you had an idea for this show.
Yeah, and I think we are going to be talking about the basic requirements and the basic implications of seeking asylum protection under the Convention Against Torture and Withholding of Removal, which are regularly the most, I would say, difficult to understand topics when someone is going in front of the immigration court. So I think that'll be a good topic to explain and to address in our next program. So on our next show, sorry. So make sure to tune in, and we'll be providing better information and more accurate information of the implications and requirements and evidence of the basic requirements of asylum.
Yeah, and I think that's going to be an important topic because of everything we see right now happening at the border. We have seen some increase in asylum seekers coming, families, unaccompanied minors, and even family members of clients that we already have that have recently entered and are needing more information about the asylum process because it is difficult, it's complicated, and so I think that's something that's definitely worth exploring and talking in more in detail about. So we have some recent news, immigration-wise. The Supreme Court issued a decision a week ago in the case called Nis Chavez v. Garland, the most recent Attorney General under Biden. And the case was about this, it's specific to cases in the deportation, defense, or immigration court process. And it's about the document that the Department of Homeland Security or Immigration uses to start proceedings. And that's called a notice to appear. And every person who's in immigration court pretty much is issued this notice to appear document that has to have certain information in it that's required by statute, right? The law that Congress has passed with respect to immigration proceedings. And the notice to appear, essentially what it says is it has to give you notice of where to appear in court, right? And in this document, it has to have your name correctly. It has to have identifying information like your birth date. It has to have your case number, your A number, that's assigned by immigration. It has to have an address for you or where they're issuing it to you at. It has to have what are called allegations, right? Which is, this person is not a citizen of the United States. This person was born in Honduras. This person entered the United States on this date at this location, or they presented themselves at a port of entry, right? And so it has the facts that make up the basis for somebody being subject to removal from the United States. And then it has a charge, right? That says you're charged with being removable under this section of the law, and it gives that specific charge. For instance, you are present in the United States without a valid visa, without a valid entry document, or you're present in the United States at a time or in a manner other that was not designated by the Attorney General or by immigration officials. And then part of that also is that it has to have the date, time, and location of your court hearing, right? The idea of a notice to appear is that you have notice of when and where to appear. So for years, when immigration issues these documents, what they've done is they put to be determined, right? Date to be determined, time to be determined, and sometimes even the court address was left to be determined or blank. And so there's been this battle for the past, specifically the past few years. There was a case in 2018 that came out, Pereira, that held that the notice to appear had to have all of those elements, including the date and time, that needed to be provided to the respondent in these proceedings. And so, as practitioners, we understood that to mean that a notice to appear had to be complete on its face with all the information, including date, time, and location, which for years has not been included as an administrative convenience for the Department of Homeland Security. And so this Pereira case came down. Several cases were terminated on the basis that, the notice to appear doesn't comply with the requirements. That went up on appeal. Different circuit courts held differently, and ultimately the case went back to the Supreme Court, and the Supreme Court considered it in the context of cancellation of removal. And now we're going to spend some time on a different topic that we have planned for today. But essentially, for cancellation of removal, somebody has to prove 10 years of physical presence, and there's this thing called the stop time rule that when somebody is issued the notice to appear, the clock stops. So if you have 9 years, 364 days, and you get your notice to appear, then you don't have the 10 years, right? Well, it's important because if you're not actually issued a notice to appear that's compliant, the question was, does that still stop the clock? And what the Board of Immigration Appeals and some circuit courts had held was, if the notice to appear was issued and only, it lacked the date and time, but later the court, which is supposedly a separate entity, issues a notice of hearing, which has the date and time, that those two documents together were sufficient. And basically that the government could meet the requirements under the statute in multiple documents. Well, the Supreme Court held that was a no-go, right? That the statute's clear that all the information has to be contained in one document. Is an interesting split with Gorsuch writing the majority of opinion, and Justice Thomas and Barrett, one of the newest justices, also sided with Breyer, Kagan, and Sotomayor for a 6-3 opinion, basically holding that the government has to comply with the statutory requirements. That the government can't cut corners for administrative convenience. And one of the good lines from the decision is Gorsuch says, all of us have to deal with this every day, right? You put a form into the Social Security office or some other government agency, and if you miss something or you don't fill out something correctly, it's rejected.
Right.
And the government is also should be held by those same standards. So it was a good decision because it essentially means that people who thought they might not qualify for cancellation or removal may now qualify for cancellation or removal because the clock never stopped running.
Yeah.
And so they continue to accrue physical presence. And it also means people who were ordered removed in absentia have an argument that they never received proper notice under the statute, as well as the notice to appear was deficient. And it could also possibly mean that in cases where the notice to appear is not deficient, you could move to terminate for an insufficient NTA, which we're gonna wait. We're gonna see if there are judges that buy that argument and agree with that, and also that there's a claims processing issue, right? That the administrate the way these proceedings should be conducted, the government is not complying with. It's interesting because if you think about asylum for a while, for the past few years, if you left a blank space anywhere in an asylum application, those were rejected. And that could prejudice the client because then maybe they missed the 1-year filing deadline and it could affect their case.
Right.
And so for just like, even if somebody doesn't have a husband or, and they left a blank space on NA, it caused a rejection. And so now we're seeing kind of that, thankfully, by the Supreme Court saying that you're going to be held by the same standards, which is the right decision. So we're going to see what the full implications are, but it's good news especially for respondents who are in immigration court proceedings.
And I also believe that this is a very significant decision because I'm talking from the perspective of our practice, like the practice on a daily basis, and they're going to court on a daily basis and dealing with clients who may be qualified only for asylum at the time when the NTA was filed, but considering all of how delayed the responses from the immigration court in San Antonio, for example, are, they can actually qualify possibly for cancellation or removal in the future if we see that this decision is still standing in a couple of years, because I think there is a lot of ongoing conversations of how long is this going to last, right? Because of all the implications that this decision is going to represent in all the cases nationwide. So I think it's going to be interesting. Our conversation in the office is we're looking forward to see how this situation unfolds in the upcoming months, especially when the courts reopen, and see how we can actually take advantage of this decision.
Yeah, and I think it's caused us to really review the cases that are coming up and screen cases a little bit differently because now people arguably have a new claim for relief from deportation, and so it does have implications, and it will be interesting to see what moves forward, because I think even though not a single circuit held that it affected jurisdiction of the court, that I think this decision has some good language that makes it arguable that the NTA does have to have all of the, it's said it twice, right? The Supreme Court has said it twice in Pereira, and now in this Chavez, that the notice to appear should have all of the information in those documents. And so I think there's a stronger basis to now challenge that when the NTA doesn't have all the information. NTA notice to appear, right? So we'll see. I mean, I can already think of cases that it's going to benefit. One case that I was thinking of how I was going to have to fight that exact issue in court, and now it's become clear and it's come down on the side of the client in our case for sure. So let's shift gears. That took longer than I thought. The other update I thought of is immigration courts. Right now they are still closed. And I think last week they issued an announcement that they'll remain closed, non-detained at least, through June 11th.
Okay.
So we're going to continue to monitor that. We hope they open soon because we do have clients that want to present their cases, and sometimes it is time sensitive issues, and so we're hoping that we see some kind of normality and reopening of the courts soon. So we're going to talk today about naturalization, citizenship. Which is, we've seen a lot of these cases in the past year. One, because there was proposition to increase the fees, and so we made a big push to try and get cases out so that people wouldn't have to pay that significant fee increase. And thankfully, that was stopped. Right, that was enjoined by a court. And also for people who wanted to vote and to exercise their rights, once they become a citizen. And I think also just for too, people over the past 4 years felt some kind of insecurity. And once you do become a citizen, right, that you're not going to be subject to removal or separation from your family. And so it's a more secure position. And it is nice, when we see that result at the end, especially for clients that we've, either helped become residents or their asylum case and then their residency and then kind of that final step as a citizen. And then maybe even then after to petition for family members. So it's like a full circle. So, Roberto, can you tell us a little bit, what do you need to show? What's required for you to apply for citizenship?
Of course, and here in the office, we work strongly in screening the potential new clients that we have for naturalization. Really good in terms of the criminal record, right? That's one of the main things that we need to check to be sure that they won't find any potential issue down the road, especially when they go to the interview. So one of the first requirements is 5 years of good moral character. If you had a criminal record in the past 5 years, we'll need to take a look to what kind of violation or crime you've been accused of or you've committed, so we can actually see if that could potentially turn into an issue in the future. So that's number one. Number two, the time as legal permanent resident in the United States. So the general rule is that you need to be a legal permanent resident for the past 5 years in order for you to qualify for naturalization. There's an exception there, and that's when you are married to a U.S. citizen for the past 3 years, then you can actually apply for naturalization. The other exception I was thinking about is, for example, with asylees, people who won their cases in asylum, that they first were asylees for 1 year, and after that year they were able to apply for their status as legal permanent residents, and they don't need those 5 years because the first year as asylee counts toward the final count of the 5 year, right? So it's a weird calculation, but in general, you need 5 years of status as legal permanent resident. The third requirement is the USCIS fee, the fee that immigration charges for you to apply for naturalization. And that's $725. Regarding the immigration fee, if you are in need or if you meet some requirements that immigration actually has, you can apply for a fee waiver, and that way you won't need to pay either the full amount or you won't pay a fee at all. And the last requirement is the passport photos. 2 passport photos for the application, along with the application itself, the payment, and if you had the time as resident and you have no criminal record, you should be good to go. So that's for the application. Once we file the application, it's really important also to keep track of how many times or how many trips you're taking out of the United States, right? Because we've had some clients in the past that had spent a good amount of time outside the United States, and while the USCIS requires at least more than 50% of your residents within the United States, we need to be careful on how much time you spend outside the United States, and make sure that we are we're preserving that presumption of residence in the United States to avoid an issue in the future. So I think that's all I can think about as far as requirements in general.
Sure. So I have a few follow-up questions. So if I'm married to a U.S. citizen, right, and I got my residency through my spouse.
Yeah.
And now I'm getting to the 3-year mark where I can apply for my citizenship. Do I have to stay married to them?
I mean, once you're a U.S. citizen, you can file for your
But what
naturalization,
about before? Do I have to stay married to them while I'm applying for my citizenship?
If the only thing I can think about right now is if you're a conditional permanent resident, right? Is that what you're talking about?
Well, so yeah, I mean that's one part of it, right? Like I have to remove the conditions, and that could be like a topic for another day as well.
Yeah.
But let's say my conditions have been removed. I hit the 3-year mark, and I've divorced my spouse.
Okay.
Can I still apply at 3 years?
Yes, you can.
No,
Right?
no,
No?
yeah, no. You have to be married to your spouse if
Okay.
you're applying at the 3-year mark.
Okay.
So I think that's important clarification, right? So if you got your residency through marriage, and you hit the 3-year mark, but
That's true.
you're not married to that
That's
person
true.
anymore, then you don't qualify for citizenship at the 3 years.
Okay.
You don't lose your residency; you still remain a resident, but you have to wait the 5 years.
Okay, the 5 years. That's what I was thinking of.
Trick question.
The 5 years and compared to the 3-year mark. Okay. Got it.
So I think that's an important clarification because sometimes we have people who, well, I adjusted through marriage. Can I go ahead and do it at 3 years?
Yeah.
But if you are no longer married, one of the requirements to do your citizenship at the 3 years is that you're still married. So let's talk a little bit more about, and I know we had a recent case where we had to address this. What happens if I do have long periods outside the United States? Like let's say I stayed out. What is your general recommendation? What should I try? What time period should I try and avoid outside the United States? How do they look at that presence issue?
You need to make sure that you don't spend more than 6 months continually outside the United States. And if you do, it's very important to maintain that presumption that you kept your main place of residence in the United States. The way we dealt with that issue was with evidence and documents that this person kept her residence in the United States. So we attach, for example, declarations of people or affidavits from people who were actually aware that she was back home for that period of time because she was taking care of her family members or whatever. We also attach a copy of her leasing agreement that she kept her house here, a letter of her employer stating that she had a job when she left, and that job was still waiting for her whenever she was done with whatever she needed to take care of back home. So I think those are really important documents.
And I think part of what our argument was is that it was out of her control, right? And initially she went to go visit family. Family member got sick. She had to stay longer than she anticipated. Yeah. That part was outside of her control, and her intention was never to abandon her residency in the United States. Her intention wasn't to stay outside of the United States that long. She did continue to maintain her residency here, and so that was kind of a unique case where we had to address those issues of presence outside the United States in this particular for more than 6 months, because really what immigration is going to look at it is more than 50%. So in the past 5 years, you have more than 2.5 years outside the United States, and not consecutively, right? Because we don't want any evidence of more than 6 months. But were you outside, for multiple times, more than 2.5 years outside the United States? Because there is this idea that if you're not living here at least half the time, then are you really residing here in the United States?
Yeah, right.
So I think that's important. Some of the other issues we run to, so like criminal history. If I have been arrested, what do you need from me?
We need a copy of the court's disposition, and in general, we take a look to every single document you have from that criminal record, because maybe you have and most of the clients get here when they were put in probation, and they just get here with the documents, the probation documents, right? And that is not enough, because we need to actually take a look to the disposition of the case. That's a document that is generally issued by the court, so you will need to take a look into the county records to get a copy of that so we can take a look to the charge and see if you can find any potential issues in the future. So we will need to get a copy of that to include in the application. If you have your probation document, we will also need a copy of that to include in the application as well. And I think that's all I can think about as far as criminal records.
And what about, I have 4 children and I owe significant amounts of back child support. Will that affect me?
We've had that issue here before with some clients. Good thing for them sometimes is that they are in a payment plan, right? So, because sometimes the when someone owes money to in child support, that can be presumably something that is not a good moral character, right? So you can find issues in that regard when you are already in a payment plan taking care of that debt. Then you can actually apply for citizenship. So our advice is if you're having some issues or financial issues related to child support, is you better put yourself on a payment plan so you're able to apply for naturalization.
And I think too, that's something we take a careful look at, because if I owe like $18,000,
Yeah.
then an officer may look at that differently, like than somebody who is maybe like $2,000 and is aggressively paying that down. So, but you brought up a good point, because normally we think of good moral character. Well, let's look at criminal history,
Yeah.
but there's other things that an officer will look at as far as, well, does that call into question that person's character? Another one would be taxes.
Right.
So if I owe back taxes, is that going to affect me?
Same situation. So when we have a case like that, we need to take a look to the 1040 form and see if they are up to date with their taxes, and if they owe some taxes, if they are already in a payment plan. Because the same thing as Guillermo was explaining a few moments ago, if you have a significant debt, an officer can actually understand that as something that is not related to good moral character and deny your application. So I think that's all I have regarding.
Now, I've been a resident for a long time, and I got my residency before I was 18 years old. Is there anything I need to show as far as selective service registration, or is the government going to look at that? And what if I never knew about it and I forgot, or I never did it?
Especially when you get to that question, the period of time that you need to be basically enrolled is between 18 and 26 years old, right? So our advice to our clients is, if you haven't, please register, and we just need to include that number. If you did not register, we can actually provide an explanation of why you did not. And that's the way we deal with that issue in the office.
Yeah, no, and sometimes clients did register and they just didn't know. It
Yeah.
maybe was at the driver's license office or wherever, and or for whatever reason they filled it out, but they didn't know. So there is a way to verify that, like on their website, selective service, you can pull up under name and date of birth and social security number and see if somebody registered. And sometimes we've had luck pulling that record.
Yeah.
Otherwise, if there's no matches, for that name, social security number, date of birth, then we have to provide an explanation. And so we've helped clients, with an affidavit of why they didn't register, were they not aware, just to show that it wasn't something intentional. They weren't trying to evade selective service, but it was really some kind of innocent mistake that happened. Right. What about, you talked about some of the evidence we include with the application. If I got my residency through marriage, regardless of whether I'm applying at 3 years or 10 years now for my citizenship, do I need to include any of those documents as far as like marriage records?
Yeah, we need to include a certificate of marriage. That's the document we regularly use and include. And if you're filing at the 5-year mark and you got divorced, then we'll need to include the divorce decree. So very basic documents. I think naturalization is one of those. I wouldn't call it friendly, but as far as documents, I don't think we'll need as many documents as we regularly attach to an application.
Okay. Now, I don't speak English.
Okay.
¿Cuándo puedo tomar el examen en español?
Okay, and that's a really frequent question we get here. So, in order to qualify to take the exam in your language, whatever language that might be, Spanish, French, German, whatever, you will need to comply with what we call the 70 rule. So, you need to be at least 50 years old, and you need to be a legal permanent resident for the past 20 years. The other option is being 55 or older than 55 and a permanent resident for the past 15 years. There's a third one, right?
Yeah, so what if se fue la memoria and I can't remember 100 questions?
Okay.
Because what is the exam? You have to study civics, right? Reading, writing in English. There's 100 questions. And generally at the exam, the time of your appointment, you're asked 10 of those and you have to answer 6 of those 10 right. So is there a point at where I don't have to study all 100 because I'm a bad test taker and I don't know if I can do 100 questions?
Yeah, and I'm thinking right now about 2 different situations that we've also experienced here with a couple of our clients. So the first one is when you are older than 70 years old, you can qualify for a reduced portion of the test. And that'll mean you'll need to study 20 instead of 100 questions, and you need to answer, they will ask you 5 questions. Is that okay? 25?
20, that you still get the 10, but you have to answer 6 correct.
Okay.
And you only study the 20 questions. And I think it's 65.
Okay.
Okay, age.
Older than 65. And then the other one is when you have, for example, people with Alzheimer or a serious mental condition that is not letting them take the exam. There is an exemption for a medical disability. We'll need to comply with a form that USCIS requires, and usually the only way to get that form is through your medical provider. So if you have a psychiatrist or a psychologist that has been treating your condition for the past 4 years, whatever time you might be experiencing that issue, then we can actually get that form certified by the doctor. We can actually attach that form to the application, and that is the other way that you can qualify to be a U.S. citizen without taking the exam.
Yeah, that's a good point. Now, I've prepared all the evidence, signed the forms with you, we've submitted to immigration. What happens next?
We'll get the notices within, I would say right now, 4 to 8 weeks, hopefully. And after that, they're getting the appointment at the ASC to take the biometrics, the fingerprints, and the photograph. Then you'll get scheduled for your interview. Once you complete the interview and the exam successfully, before, I think right after the exam, they were being scheduled for the ceremony right there, right?
Mm-hmm.
Right now, what we have seen is that they are scheduled for the ceremony within 4-6 weeks, more or less. And that's when you go to the USCIS office. They give you your certificate of naturalization. You take the oath, and you're basically welcome to the United States.
Yeah, and so I think each process is differently. Here in San Antonio, they've been processing the cases pretty quickly, and we had seen sometimes it happens that the person has their interview, everything goes well, they're recommended for approval, and I've been in an interview where they say, okay, come back this Friday for your oath ceremony, or even come back this afternoon, we're having an oath ceremony. And so that's great because it gets people processed and their certificate of citizenship quicker. So that's kind of a good thing that's happening. So, I think we have a question. I thought I saw a question about that.
If we speak. Sí, hablamos español.
Yeah, y eso es algo que tenemos Facebook Live todos los jueves, pero el jueves de esta semana es durante la hora de almuerzo a las 12 en inglés. Y el próximo jueves vamos a tener otro show en Facebook Live a las 6 de la tarde y eso es completamente en español. Pero sí hablamos español y si usted tiene alguna pregunta, usted puede poner su pregunta en los comentarios en español y con gusto podemos contestar su pregunta.
Y creo que es todo por hoy.
O usted puede comunicar con la oficina. Our number is 210-922-8541. We do offer free initial consultation, either by telephone, Zoom, in person. La consulta es gratis, la primera consulta es gratis. Just call our office and we'd be glad to help you with naturalization or whatever other kind of immigration case you have. So I think that, we kind of hit briefly the process of naturalization. There's literally, we have like a book this big about different things that could happen. But I always think, anytime is a good time to apply for citizenship if you qualify. So you can vote, you can be more active in the political process, and also there's a security, I believe, that comes with it as well. So I think that's all I have for today. Anything else, Roberto, that you were thinking?
I think that's pretty much all. But we will need to address some more issues that could come up.
Yeah, well, thank you everybody for joining us. Again, I'm Guillermo Hernandez, Roberto Campos. We're immigration attorneys in San Antonio with Vidal Rodriguez and Haynes. And if you have any questions, we invite you to give us a call and let us know how we can help.
Thank you.